I am a card-carrying member of the deep state. It's this element that maybe a lot of people don't understand about the patent system is that true innovation comes from the ether. Silicon Valley internet-based content companies just went to town with that.
Welcome to Clause 8, the #1 podcast on intellectual property, hosted by Eli Mazour.
I wasn't sure anybody even remembered who I was.
Let's start from the beginning of, I guess, your IP journey. You were born in Wisconsin, you grew up in Wisconsin, you went to school in Wisconsin, you got your first job in the legislature there. What brought you to D.C.?
The U.S. Army brought me to D.C. It was the Vietnam War, and I was commissioned as a lieutenant in the Army. And the bottom line is I ended up being posted in Washington. I'm very proud of my military service, but I'm very careful to say that I'm a Vietnam era veteran, but not a veteran. I had a really cushy desk job in Washington, and I was going to go back to Wisconsin. And then at the last minute, the job that I'd lined up fell through, and the U.S. Justice Department had offered me a job, and I didn't want to take it, but I took it because I didn't want to be out of work. And so I went over there for a few months, absolutely hated it. I decided if I'm...
What was the job?
Well, I was actually in the criminal division, but I was in the national security section. Yeah. And there are great jobs in justice, but I didn't have one. I was put to work writing certiorari memos, in other words, reviewing criminal cases which had been lost by the government, because of double jeopardy. Generally, you can't appeal, but to look for opportunities to appeal a decision. It was boring as hell. I had a horrible boss, couldn't stand it, and I said, I'm only staying in Washington if I can have a real Washington job. And that meant not being a civil servant. I wanted to be... I was terribly arrogant. And I thought, well, I'll work in the House of Representatives as a committee counsel. And in the Senate, I'd work either as a committee counsel or as a legislative aide, because the Senate works a lot differently. Those jobs are more fungible. But so I went to my senator and my congressman and said, here I am. And a couple of months later, I got a call. And at the age of like 28 or 29, I became counsel to the House Judiciary Committee.
And who was the congressman who brought you?
The congressman from Madison, Bob Castemeyer, who was a very liberal congressman. Well, in fact, the person in that seat right now, Mark Pocan, is probably one of the most left-wing members of the House. So it's historically been a really liberal area with Madison and everything. And he was a very senior member of the committee. He had a subcommittee that could have practically whatever he wanted in it. It was called the Subcommittee on Courts, Civil Liberties, and the Administration of Justice. And among other things, had a big sweeping portfolio. For example, I worked on the Foreign Intelligence Surveillance Act, what became a Foreign Intelligence Surveillance Act. But it also included all the patents, trademarks, and copyrights. And there'd been a long-running effort to revise the 1909 copyright law. And so I was put to work on that. In fact, we're having the 50th. There's going to be a Zoom conference on May 7th of the still surviving living people that had, who worked on that legislation. And then I was put to work on the patent policy provisions of the Non-Nuclear Energy Research and Development Act of 1974. I had never taken an IP course in law school. I had not a clue, but when you're writing the laws of the country, you have to have to get to learn pretty fast. But I found with lawyers, like actually, in more recent years, I've worked sometimes as an expert witness with patent litigators, and a lot of the best ones aren't even patent lawyers. I mean, per se, they're really good litigators, but the best ones are super smart, and they can absorb the most complicated technology and figure out how to make a case for their clients. And so, I mean, that's what being a good lawyer is. So anyway, I tried to be a good lawyer, and so I learned that subject matter.
So did you like the IP policy issues more than the other issues you?
Well, no, not necessarily. I became fascinated by it. I mean, because it's really interesting. And I think it wasn't, the thing that I ended up working on the post-Watergate reforms, which, among other things, led to FISA. We had big oversight hearings over the FBI, and it was, sort of the stuff of the movies. And that was fun. Everything was exciting and fun, but the IP stuff, I really immediately could begin to see its importance, because even then, I mean, it sounds quaint now. I mean, the technologies at the time seemed like the Stone Age now, but we were on the cusp of a technological revelation, a revolution.
And this was the late 70s, early 80s, right?
Yeah. Well, they're actually. This is an important point. I mean, if anybody wants some wisdom from me, I used to, for many years, give a speech that I called the Patent Pendulum speech. A lot of people used to identify me with that, and how, since the Constitution, since we're having this is the 250th anniversary of the Revolution, not, of course, the Constitution, which was 1789, but and by the way, my lifespan has been 1/3 of that time. We've gone through periods of high protection and periods of low protection. And so, like, for example, in the 19th century, inventors were some of the most famous people. Abraham Lincoln has a patent, and the patents were extremely important. But what happens is, and they spurred, technological innovation in this country and the other countries that had patent systems, like Germany and UK and Japan, by the way, which adopted patents in the 1870s. But then what happens is you develop these industries that become phenomenally successful and dominant and are consolidated, and they lose interest in intellectual property. In fact, generally speaking, oftentimes they become hostile to strong patent protection because they want to be able to steal the little guy's stuff, because their prosperity depends on market power. If they have market power, they don't need IP. And so what happens then is that sets in. Well, then, as in all things, when people get in power too long, and they get too rich, they get too lazy, everything, of course, they become less competitive. And particularly in an era of international trade and so on, they start to lose market share. And so then you have to do something about it. And so that's when all of a sudden, well, maybe we ought to take a look at the patent law again. And so, we had that period. I would say we had pretty strong patent protection. Even I mean, we had antitrust laws that came, but we had pretty strong patent protection, I would say, certainly up into the early first part of the 20th century. And then we had the Depression, and we had World War II. And of course, then we had this huge infusion of government funding of technology, which spurred a huge technological revolution. And so at the end of the world, we dominated everything. We had, automobiles, electronic industry, chemical industry, and so on. But these companies were just enormous. They had tremendous market power. Well, then what happened is, the Japanese started coming into the picture, and whittling away we lost our consumer electronics industry. And so starting, and that's when I first got involved in this, in the 1970s. It really even started maybe under Johnson, and it was bipartisan. You had both in the front offices of corporate power, and then also in the government, you had people say, well, we've got to take a look at this. And so there was actually, I think, the National Association of Manufacturers or something set up a competitiveness council. There was a government equivalent to that. And there was basically review. And one of the most important things that was done, which I worked on and became law, was the famous Bayh-Dole Act, which is a pretty simple statute, but I think had an unbelievable impact because government was financing all of this basic R&D, and the rule always was that which would seem logical to a lot of people. By the way, the government insisted if you got government money, you should, if there were identifiable patentable inventions, you should file a patent application. But once you got the patent, the rule was that if government spent one dime to finance it, if you were a university or laboratory or a government laboratory, that it had to be licensed on a non-exclusive basis to all taxpayers. Well,
Before the Bayh-Dole Act.
that just obviously there's no incentive to invest because the basic research, particularly the kind done in academia, is, when you look, say, at the pharmaceutical industry, you've got to go, where the capital is involved, enormous investments, is clinical trials, all those sorts of things. It's not really in identifying the basic invention. And so we changed the law, and it's unbelievable the effect that it had. And so I remember the first time I ever went to Silicon Valley, it was actually to look into prison issues out there in what's now Silicon Valley. And that area south of San Francisco was pretty depressed. Today it's one of the richest places on earth. And when you think of what is Silicon Valley, it's in the Northeast. You have UC Berkeley, and you have University of California, San Francisco, which is the life sciences campus of University of California system. Then you go down to Stanford, and then you go across to the Lawrence Livermore Laboratory. And so you have all of this world-class, science. And so today, because of the Bayh-Dole Act, you can be a professor at Stanford, you can invent something, and of course, the rule is, because you have to file the patent before the disclosure, that means that before any scientist can publish, before you can give a speech about it, these universities, they have a patent committee that reviews the work, and then if they feel there's patentable subject matter, patent application is filed, which the university owns, and it's a big source of revenue for, like, my alma mater, University of Wisconsin had the first patent licensing operation in the world, and has a multi-billion-dollar endowment just from that. And UC, that University of California has the biggest one by far in the world. And so the professor Now, he doesn't own the patent, university does, but guess what? When the venture capitalist puts together some money and they start a firm, he, of course, gets on the board of directors, he gets stock options, and so he ends up a billionaire,
Yeah.
continuing his job as a professor, and also getting money to finance his research, and then he can win the Nobel Prize. I mean, he's got everything,
Win-win.
and
And we all benefit from that.
and that's what happened, and that's why. So we had this huge boom. It was hugely successful, and then, this extended out. There's a copyright component to all of this too, because of content industries and copyright, and that was something that was very central to the Clinton administration's economic and trade policy. But what's happened now is that it was so successful, we're back to that situation where market power is everything. Because these guys have market power, they don't want to be bothered by some gnat patent holder, if you're a Mark Zuckerberg. And so we're right back again, and we're in a period of low protection, I would say.
Yeah, and you're even hearing stuff about the Bayh-Dole Act and stuff like that, about maybe marching rights and all that. So you could definitely see the pendulum swinging, like you said, the other way.
Well, the great irony is that all these people, I mean, the Obama administration was filled with all of these information should be free, et cetera, et cetera.
Yeah.
And of course, they had a love affair a little bit with these emerging Silicon Valley companies. Of course, now they're all over with Trump, I mean, so much for that.
I guess it was a perfect recipe for anti-patent sentiment, because the
Well,
large tech companies and I guess some on the more progressive ideological side who think
well, there's a big
companies should-
copyright component to that, because in obviously software is copyrightable subject matter, but also content. I mean, that fits into the AI thing right now, and we've had some, in my view, absolutely catastrophic. The evolution of the case law over the last 20 years has been catastrophic also in expanding the doctrine of fair use to something that's just vitiates copyright, and you see it in AI. I mean, I guess one reason I'm not worried about, I mean, we can worry about AI, but I'm not worried about ultimately AI taking over everything, is that basically what AI does is it soaks up all the existing databases of content.
Yeah.
And then it's able to, sort through them and focus on it, organize it into something useful, maybe even to the point of, for example, being able to write new code and things like that. But what it cannot do, and this, which is this element that maybe a lot of people don't understand about the patent system, is that true innovation comes from the ether. And in fact, what's the test for getting a patent? Novelty and non-obviousness. And that's why we have an examination system, because you have to prove that. That's why the invention has to be something that is not obvious to one ordinarily skilled in the art and has never been known anywhere in the world before. Unlike copyright, it doesn't, there's not a copying test. And so where's it coming from? Well, it's coming from somewhere out there in the ether. And it's interesting, when we used to have the first to file system, I mean, the first to invent system
for patents.
we had, we had to have the
Interference.
interference, yes. But it's interesting that just an interesting phenomenon, I think, throughout history is that you tend to find these inventions popping up all over the
Yeah.
world.
Parallel inventions. Yeah.
Yes,
Yes.
and it's otherwise it's sort of
Different.
dawning on human minds, and so there's this metaphysical element to it,
Yeah.
and that is not. I mean, who knows? I don't believe that is something AI can do or does. However, coming back to copyright, what AI companies are doing is that content database they're soaking up is data created by someone else.
Yeah.
And, under the current case law, basically, those content creators whose works have been are being used by this database have no stake in it. They have no right. And I think that is just fundamentally immoral. It started out with Google. I've always been against Google. When we had some cases, there was a famous case about
Google versus Oracle. Or
no, this was a copyright. It was Google was they basically digitized libraries.
oh yeah, the books.
It was a library case, and the Association of American Publishers, a lot of publishers brought litigation because, in my view, correctly, even if they weren't copying exactly, they were still making commercial use
Right.
out of the previous
Absolutely.
work.
Yeah.
And so as I recall, it's been a long time since I've read the case, but it was determined it was like a card catalog, for example. So, the court said, well, this is nothing more than, it's like a card catalog thing for, it's not the whole book. It's just because you're only, but if you if you do Google something, you will get whole excerpts. And
Right.
if it's in the area of, for example, visual arts, like I worked a lot with professional illustrators, you'll see the whole illustration often. And so that just opened the barn door. And then also going back even earlier in the software cases, the transformative doctrine,
Yeah.
in other words, if you transform the work, then, you have a I can steal it card. And also you had this whole period of weakening right at the time you were having these new technologies, and particularly the Silicon Valley internet-based content companies just went to town with that, and now they're just the most awful, evil organizations on the planet.
So I want to circle back to that, but obviously during your time when you were head of the USPTO, you helped pass the Digital Millennium Copyrights Act, which was the rise of the internet, and I think like Napster and all that, and that was partially to strengthen copyright in that time. Now there's conversation, like you mentioned, about AI, and you are hearing about some deals between content providers and these AI companies. But do you think new legislation is needed to strengthen?
The short answer is yes. I think I just turned 80. My life has been 1/3 of the history of this country since the Republic, since the Constitution. And just if you think of the two other 80-year periods, what's happened, the changes that have taken place, unbelievable. And again, you see this pattern where we're at the end of a period. My life, I was born a couple of weeks after the end of World War II, into the atomic age and into the golden age of America. I think we were on a sort of slow decline, but with President Trump's second election, we've gone over the cliff. And so that era is totally finished. And so right now we're in a deconstruction period. Which is always very painful. I mean, and a lot of people end up suffering where the old world has to kind of collapse before a new one can be built. But since I spent a lot of my life, in legislative policy with regard to copyright, always one of the most difficult things is to, in trying to keep up with technology and, amend law, is that you have all the existing interest groups. It's very hard to write something from scratch, and I would say the statutory changes that have been made during this entire period that I described were things that weren't just necessarily wholesale revisions, but we're now at a period when everything is going to be basically so destroyed that the next generation of policy makers who are just now starting to appear on the scene will basically have, I think, the permission from the electorate to really just write all new rules governing all these things. And one of the things that clearly has to be done, historically we're at a period a little bit like the end of the Gilded Age, and you had a progressive followed by progressive era when you had antitrust laws, you had regulation of consumer laws of various types, regulation of.
So we were talking about how in Congress, when you worked there, it was a pro-IP era, and you got to work on a lot of that. And then Bill Clinton gets elected and you become the head of the USPTO. Can you tell us a story about that? How did you get chosen for that position, and why were you interested in that role?
I knew I was going to be a lawyer when I was 14 years old, but I was interested in politics and government. And I never saw, I now realize lawyers can earn a good living, and I did, but I didn't approach it I didn't go to law school to make money. I wanted to, promote truth, justice, and the American way.
Yeah.
And so I was really interested in public service and so on. And so, when I left the Hill, I realized, the time had come when I needed to. And one of the nice things about the IP thing is that was one thing you could at least make some money from. And so I became a partner in a law firm and did that. But I always wanted to. I always had this idea that, the firm was a firm called Swidler and Berlin. It doesn't exist anymore. It was eventually merged into Bingham McCutcheon. And it was a very successful law firm during the period of time I was there. And but I wanted to go, my objective was to go back into the government. And since the moment I made the decision to stay in Washington and go with the committee as opposed to go back home to Wisconsin, I realized that if I was going to be involved in the political world, that it would be as an appointed official, not as an elected official. And I also figured, the highest you can expect to get without the finger of God touching you is basically a sub-cabinet officer, an assistant secretary, undersecretary. So I had my eye from that time on the Hill on the PTO because I could see its potential. And so when Clinton came in, I
And
went for that.
You were able to see its potential? What were you able to see before you got the role?
Well, first of all, it's a sub-cabinet Senate confirmed position. But I also could see that it could be a lot. I remember when I was a young lawyer for the committee, I think it was what became the AIPLA. Every year had a reception for patent examiners. The patent office was in horrible shape. and these and they would have it on the Hill in like the Cannon Caucus room, and you would go to the thing, and it would be pretty pathetic. All these guys in their white short sleeve shirts, their pocket protectors, and then scarfing up the sandwiches and so on and so forth. And patent office was underfunded. That was not one of the big reforms we made, is to change that. And so it wasn't. And in fact, the head of the patent office, even though it was, had been really part of the Constitution, reported to an assistant secretary, reported to an undersecretary. And so before I left the Hill, I helped to change that and make it, working with Reagan's patent commissioner, Jerry Mostinghoff, and we did all these reforms, which Bayh-Dole was part, but the big part was reforming the patent office and putting it on a fee-funded basis, raising the commissioner to an assistant secretary, reporting directly to the secretary. So, I mean, you're just one step away from the president, and so I went into private practice then, and waited my time, and I thought, well, this is a good thing. I could, and I knew all the people. I knew a lot of connections, and I campaigned for Clinton. I was pretty active in the Clinton campaign, and I was nominated.
What was the confirmation process like? Going through that for the first time at the time.
It was a breeze. I had no problem. I was confirmed, but there's a reason.
Yeah.
Well, I mean, it's particularly important because probably the most historic thing that I've ever done is that I was the first openly gay man ever to be confirmed by the United States Senate. I wasn't the first gay person because Roberta Ackenberg, who was Assistant Secretary of HUD, had been a San Francisco supervisor. She was confirmed like a couple of months before me, but when her confirmation came up, a third of the Senate voted against her. And Jesse Helms, the senator from North Carolina, gave this big famous speech where he said, "I'm not voting for a damn lesbian." I was confirmed unanimously. And I knew when I was when I had it made, is that when I went up to see Senator Thurman, and he said, "I want you to know I'm supporting you." And that's because I knew Senator Thurman. I knew all of the, I remember I was supposed to see him in his office, like for my courtesy visit. And there's a big room behind the Senate Judiciary Committee chamber, and it's where everybody goes. All the staff hangs out there, and the senators go there when they want to take a break from the committee room. So they said, well, he was presiding over the committee, and so they said, well, you've got to meet him in that room. So I walked into this room, which is filled with all these people that I knew, every last one of them, all of the staffers, and I knew everybody, and I was a member of the club.
Yeah.
I am a card-carrying member of the deep state.
Well, that's a great.
Absolutely, 100%.
That's a great story that shows how personal relationships, make a difference. You obviously were involved in a lot of those issues. Were there any pressing issues when you came in? You're like, this is what I want to accomplish as the USPTO director that really stood out to you?
Definitely. Yes. Oh, definitely. Yeah. It's hard to appreciate. Things have changed so hugely in such a short period of time. It's hard to appreciate how recent a lot of things that we, the device you have in your hand, how recent that is. When I was a young lawyer and I was working on this legislation, I I would write things out on a yellow pad, and or any memos or any writings I did, committee reports, and I'd hand them to a secretary who would type them up in an IBM Selectric typewriter, and then we would go back and forth. So finally, we had a good copy, and I could send it off. I mean, that's how primitive things were then,
Yeah.
and obviously, computer technology. I mean, we had the PC and everything by 1993, but you have to remember the what we think of as the internet today. The internet itself was created earlier as a DARPA project, but it was basically for academia and the military, and you still had to have the numerical addresses. It was Tim Berners-Lee at CERN in Geneva, the Center for European Nuclear Research, who invented the World Wide Web
Yeah.
system, and that year was 1994.
Oh.
So when we started this work, and in fact, one of the first things that President Clinton did is that he set up this was a part of this whole policy review process of reviewing trade policy and industrial policy, and one of the parts of it was to set up something called the National Information Infrastructure Task Force, which was in the Commerce Department. And I was put in charge of developing the intellectual property piece of what became that report. So that's, and if you, I think I have a copy of it. If you look in the back of it, you will find a proposed statute, which is the genesis of the, it's the bones of the Digital Millennium Copyright Act, but it also, it worked on both domestically and internationally. So we created this template, and then we took it to Geneva, both the WTO and the WIPO, and then that was the genesis of the WIPO
Trips.
yeah, no, well, yes, all of that, and then so we were working both internationally and domestically, and so the final domestic legislation for a lot of that was really the WTO implementing legislation, but we, and I started working on that almost immediately, practically from the first day on the job.
Yeah.
And that was a process, as I said, it was very collegial. But, I mean, I was over at the White House regularly and having interagency meetings with my peers in other cabinet departments that had other pieces of that. For example, I mean, antitrust, there was a piece on antitrust. And well, the nice thing about it was that I guess that's why I think the administration was very collegial. Maybe it's because IP was so mysterious to most people that everybody else pretty much did whatever I recommended. I didn't get it. I mean, people just basically deferred to me on these other departments and policymakers.
Yeah.
Who did not defer to me, and where ultimately you have a statute that looks quite different from the one in the back of that report, is once it gets in the legislative mill, and you have and even in Geneva, I mean, the lobbyists get into it, and that's a exceedingly frustrating process. But of course, I was pretty equipped to deal with that too, because I'd spent my life up until then with all of those people.
So when you stepped into that role as USPTO director, were all these lobbyists trying to contact you and say, hey, I know you worked in this for a while, but these are the actual issues with the patent system? Anything that kind of stood out to you, what others thought at the time about the patent system?
In my career, as a policymaker, I guess you could say. I mean, I've always, I believe in openness, transparency, democracy, and so I've always had an open door to any interest group of whatever ilk. Everybody has a right to be heard. And so, there was just a lot of, we had roundtable. I mean, as I recall, we had a whole series of hearings. In fact, it's just coming back to me. Oh yeah, we had like Congress has hearings. We had a whole series of hearings and roundtables, and inviting industry people in and academic experts and so on and so forth, on a level that was far more extensive and granular than you could do in a congressional hearing. Although I will say congressional hearings today are nothing like those when I worked for Bob Castemeyer on the House Judiciary Committee. I mean, you see these scripted hearings, the 5-minute rule, everybody has 5 minutes, the witness has 5 minutes. I mean, you're talking about some, mind-boggling statutory change, and, the witness is supposed to, even a cabinet officer has, they have 5 minutes to talk about it. And then each member of the committee has 5 minutes to grandstand. And it's just a farce. I remember one thing about Bob Castemeyer, who I worked for, who was really a great statesman. This guy, we had a 20-minute rule, but he would never stick to it. So we'd get these people that would come in and they would drone on for an hour or more, and he would just let them talk. But, and in fact, I think he had a cast iron rear end. I sat next to him on the dais, and I'd have to get up and go to the bathroom during the hearing. He never did. And these hearings would go on for hours. But what happens then is that the members of Congress actually learn something, so that he was a powerful legislator, but he didn't just simply have to rely on me to tell him what to do, although he was quite receptive to my suggestions, because he actually knew a lot about stuff, because he had, I mean, when you're writing the laws of the country, one of the things I can appreciate now, which I didn't appreciate then, I was so arrogant. I was, as this young 29-year-old lawyer, I mean, there wasn't anybody in the whole country that wouldn't answer my telephone calls or come to my office. I mean, the most important law professors and business people and so on and so forth. So I started, taking it for granted, that, but so you got the information that you needed.
So in your first year, you spoke about, the GETS-TRIPS legislation got passed, which is this international agreement, related to this international agreement where, patents would be enforceable around the world, and it kind of goes in hand with that pro-patent atmosphere, which you had in Congress, and it seems the Clinton administration also supported that. One thing I guess that started creeping up in the 1990s was this talk about submarine patents. Do you remember when you first heard about that issue? And I guess, what did you think about it at the time?
It was a big issue during my tenure, and it was very much involved in the debate over going from a first to invent to a first to file system. A lot of people thought that I was very unreasonable. I mean, a lot of the independent inventor community really did not like me, because I was so strongly pushing for first to file. And it's not because if I personally were the lawmaker for the world, I would have kept our system, the
Yeah.
first to invent system, which I think is the fairer system.
Yeah.
But you have to remember that this whole thing was, I mean, the whole vision was we're going to have a new globalized economy and we are going to be at the top of it. And that means we have to have an international set of rules that you have to negotiate with other companies, the countries, I mean.
The issue for the Trips Gal legislation was really more about the term starting from the grant date versus the filing date, right? Specifically, before it was 20 years from,
That's correct.
sorry, 17 years from grant date, and now we have it at 20
That's
years
correct.
from filing date.
That's
Yeah,
correct.
that's what it
But
changed.
that was
Yeah.
the international
Yeah,
system.
yeah.
That all of our trading partners in the other industrialized countries use the other system. And if we wanted to get our way on a lot of this other stuff,
Yeah.
we had to accommodate them on some things. And that was an absolutely bottom line. That was that they were not going to cave on. And so that's why we ended up going that route. But one of the arguments for that, by the way, was to do away with submarine patents. I have to say, myself personally, I never felt that submarine patents were particularly a problem.
Yeah.
And, you talked about Gil Hyatt's, which, I got involved with him a little later on. I may or may not, agree with everything, but there's no question, looking at, by the way, those files,
Yeah.
he was not, in my view, he was completely abused and mistreated.
Do you remember that? I guess at the time, it was Jerome Lemelson and Gil Hyatt.
Hyatt, I had no contact with Hyatt. The one who just was vicious was Lemelson.
Yeah.
He hired, he spent a lot of money fighting me and also personally attacking me.
But do you remember that, dealing with that when you were USPTO director?
Yes.
Yeah.
No.
And what was, I guess, internally, like, what was driving?
I knew nothing about Hyatt's
yeah.
thing. I knew nothing about his case.
Yeah. So at the time, I guess, internally, decisions were made. Yeah.
You have to remember, the USPTO now has, what, I think 13 or 14,000 employees. It has, 10,000 examiners. I mean, the head of the office is not going to be involved in most cases,
Right.
And the only time I did get involved in individual cases, and I did on a couple of occasions, was where there were major policy or presidential matters, but in terms of interfering with the work and the judgments of the examining corps,
Yeah.
including the senior leaders of it,
Yeah.
I basically didn't interfere with their judgment very much.
Were you surprised when you learned about that story?
Yes, I
About,
was.
yeah.
I was, and disappointed, I have to say. And by the way, I have the utmost respect for the civil servants that I worked for over the years. But, given where I came from, I also, that's one reason why, going way back to the beginning, I didn't want to be a civil servant. Because I think there is a limit on the decision-making authority of civil servants. In a democratic system, it's ultimately policy decisions have to be made by the political appointee, who is, as I said, there was one person in between me and the President of the United States, and the President of the United States was elected by the people.
It's interesting. So I guess these civil servants, because of things they must have been hearing about submarine patents, took it on themselves to implement this program. where at least Gil Hyatt argues that the director was to issue no more patents. I mean, one other thing that I guess about the story that interests me is um, how long it's lasted, right? Let's say some civil servants made a mistake, but somebody could have came in over the last 30 years and say, all right, let's resolve this
Well,
mistake.
yeah, I have to say, Mr. Hyatt, I don't think really took my advice. He decided to go a different direction.
You know, it's funny because I think about that a lot. I think about it a little differently because, like, if you're a litigator, you know how to litigate, right? So if you're a hammer, you just know how to hammer, and that's what you might encourage your client to do, even though there might be.
Well, you know, it's not necessarily black and white. I mean, I mentioned earlier
Yeah.
in this conversation
Yeah.
that some of the lawyers that
Oh,
I
yeah,
have
yeah,
the
yeah.
absolutely most respect for
Yeah.
in the world are some of these patent litigators
Yeah.
that I've known who are just like mind-bogglingly smart.
Yeah.
But I will also say this, that there was a time in which I was frequently retained to do expert witness work. I never, ever, ever was able to actually get on the stand and testify. And that's because
Settled.
97% of patent cases get settled.
Yeah.
And I came really close one time, and then I had some depositions, but I came really close, but you know, the case gets settled. And that is particularly true, I think, today, at least in certain fields. Like I in the last group of cases that I was involved in were these cases involving biologics and the legislation that has been passed that sort of mirrors the
Yeah.
patent term restoration legislation, you know, where you can, the nature of the life sciences, the pharma industry has changed so hugely. There used to be a big, you know, like a great wall between patent intensive pharma companies and then generic companies. But today, particularly in the area of biologics, you know, you have, and I think that's partly because, and I'm a little weak on the law and technology here now, but it's partly because things that give you exclusivity are much weaker than traditional
Yeah.
compound patents, for example, on a chemical compound. And so these big pharma companies now are involved. They have generic operations,
Yeah.
and even if they don't, they have. I mean, look at the big thing right now, semaglutide, and you know these. And
Yeah.
I mean, look,
You might know more about this.
they're like about 4 different
Yeah.
products, and they're all basically the same thing, but
Yeah.
each one of them has its own
Uses.
intellectual property. And so what happens is that is oftentimes they'll end up bringing, you see, if you bring a case, a patent case, that's basically going to nullify a patent.
Yeah. So I want to go back just to the Hyatt story. I guess from their standpoint, you know, they went a route of litigation, which has been kind of 30 years. They went up to the Supreme Court, won. Now they're back at the Supreme Court. You know, you mentioned the cert petition, which I guess is almost in 2012. So now I guess it's like almost 14 years later, back at the Supreme Court. And the issue there is about latches. I don't know how much you've kept up with that.
I haven't kept up with
okay,
that case at all, really. I'm kind of a little bit surprised to know that it's still going.
Yeah, so we have another cert petition pending right now before the Supreme Court because they're asking the Supreme Court now. They were unsuccessful at the Federal Circuit, and they're asking the Supreme Court to take a look at that.
Well, cert petitions are pretty hard to
Yeah.
win. I mean,
but they did have one victory at the Supreme Court before, I guess.
They did?
They did, yeah, with because they weren't allowed to present certain evidence to the district court,
okay.
and they went all the way to the Supreme Court, and Supreme Court ruled 9-0 on their behalf that they were able to introduce some evidence.
I just haven't followed it. I didn't.
Yeah. So it's been a long journey. I mean, are you familiar with the SAWS program that was
Yes.
the creation? I mean, you spent a lot of your time in government.
I'm
and
familiar with it
yeah,
now.
yeah.
I wasn't
Yeah.
familiar with
I
it
guess
before.
does that surprise you? But something like that, like was created in the government. You're
Some of the people that were involved in that are people that I have a lot of deep respect for. But once I ex post facto was exposed to what happened, I just really would have to say I completely disapprove uh, of the operation they set up, the decision making, and it goes to that point that I made earlier about the division between being a civil servant and being a policymaker.
yeah,
I don't like what has happened there, but um, but you know, back during my tenure, the PAT, reexamination was far more restricted process, and so I wasn't generally that involved in it. But there was one case, as I recall, where where a couple of cases where I really got involved in things that I guess might have been involved litigation. And one of them was, sometimes the extreme right and the extreme left come together.
yeah,
And so you had one of the issues was the whole question of patents on human beings.
yeah,
And so there's this guy, Jeremy Rifkin, I think it was his name. This was a career he built off
yeah,
this, where he was on the crusade that the wicked scientists and pharmaceutical companies were, about to create chimeras.
yeah,
Where you'd be half human and half, I guess, so that you could maybe harvest organs and so on
yeah,
and so forth. Now, I have to say, personally, I have no problem with, if you call that a chimera, with engineering a pig
yeah,
that has a heart that can more easily be transplanted into a human.
yeah.
I'm all for that.
Yeah,
And
that seemed to be a good
that's
thing. Yeah.
and that was the big issue. So
Yeah.
they were they basically tried to set up a test case where put us in the position where we would, they could bring this, and I forward, and I intervened. I'm kind of mixing up my different procedures here, but one of the very, very rare powers that the head of the office has is you can disapprove of patents on the principle of ordre public,
Yeah.
and I think it might be that case. I intervened and used that. A couple of times I got involved in things that were technically
The new director
litigation.
actually did that recently as
Yeah.
well. Yeah. Yeah.
They were technically litigation,
Yeah.
but there was my opinion, important policy question. And if there's one thing that really, gets my juices flowing, as I can't stand anti-science.
Yeah.
I am a believer in science, and any political position or movement. I mean, science sometimes has to be regulated, but to outlaw areas of scientific endeavor and inquiry and innovation is something that I am, generally speaking, very hostile to.
One last question about the Hyatt saga. There's obviously new political leadership at the USPTO. Any advice to them about how they should approach this long-term situation, or any thoughts about that? I guess
I don't have any advice for them on that. I do have advice for them, which of course they wouldn't take, and that is that they should stop tormenting the patent corps. They should reinstitute. yes, they should reinstitute telework, and they should bring the. By the way, I was absolutely tormented by the Patent Examiners Union. So I'm POPA,
Yeah.
but they this whole Russell vote agenda, agenda that they have adopted
Yeah.
is just utterly contra. In fact, I can't imagine trying to actually accomplish the mission of the patent office.
And I think they're recognizing that because I mean, most examiners work remotely, and they are hiring new examiners. So I think they recognize they need. I think they announced they need to hire something like 1,000
Well,
new.
I want to say one thing about that. The USPTO, their telework policy is not something that was adopted during COVID. The USPTO was the first large organization in the world to adopt telework, and that goes back before the internet. Under Jerry Mossinghoff, Reagan's head of the patent office, and I worked with him on that. And in fact, they had to develop a whole special technology to permit electronic, I'm talking about electronic examination. I'm sorry, fast forward. It's our regime. It was Al Gore. Al Gore was part of the Reinventing Government initiative. We were selected as a guinea pig organization to test out telework, basically, for our employees. I, at the time, was not particularly enthusiastic about it. But I was a loyal lieutenant, and so and Gore himself personally was interested in it, and would speak to me about it, and so so we implemented, and it was mind-boggling the impact that it had. I would say one of the most difficult interesting thing about running the Patent and Trademark Office is that's why I think the dual title, Undersecretary of Commerce and Director of the USPTO, is actually quite appropriate, because Director of the PTO part is you're basically the CEO of an organization. The Undersecretary of Commerce part is the policy part, where you're the advisor to the administration on intellectual property policy issues, including international issues and so on. And so in terms of the administrative piece, I would say the most difficult problem I had, which is always a problem, the problem of patent pendency and keeping up with it and so on. And one of the difficulties we had is that we would have, we would hire new patent examiners out of school, and it takes 3 years for them. In fact, as you probably know, and I think there have been issues recently with that. But you have to have a supervisory patent examiner sign off up until 3 years. So, and obviously, it's going to take a junior patent examiner a period of time to really learn the job. And so back then, what we were experiencing is that after 3 years, the PTO was pretty competitive, particularly after we improved the pay structure, at getting young engineers right out of college with industry. We were pretty competitive when you looked at it. But then the PTO was in a situation, if you stuck it out and stayed and you made it, then you got ultimately the benefits of all the government, retirement and perks and everything. Then it started to, you're never going to compete with, senior executive positions in the private sector, but, more or less just junior, mid-level tech positions and so on. I think the government's pretty, and the job security, which they used to have, all those things are pretty good. So, but you get this point at 3 years where there would start to be this pay differential, because, as you know, a patent examiner can go out and be a patent agent,
Yeah.
and automatically can register even without taking the exam.
Yeah.
And so,
At least that was the case. at
yeah,
least
there
it
was.
Yeah,
Anyway,
yeah,
so you would get all these people that I remember when I was at Aiken Gump. I mean, we would hire these people. I think I mean, I'm talking 25 years ago, we paid them $90,000 a year, I think, was much more they get in the government. And so, so we were losing people.
Yeah.
I don't, I think, I can't say today, but as of the end of 2024, when we had a third of the turnover, a third of the employees turned over every year.
Yeah.
We would get all those people. It was a huge problem. Just when they start
Yeah.
to know their job, they left. That turnover rate was down to, I don't know, 4 or 5% as of the end of 2024. Now, I think it's all different now because, you know, Doge came in and fired and tortured people and, you know, all these things. So I don't know where they stand, but
Yeah.
but that reform of telework
Yeah.
transformed everything.
Yeah.
And, you know, even and I don't know how they're handling that, but even as you probably know, you probably practice, if you assuming you practice there. I mean, the PTAB hearings, I mean, you'll have the judges will be in different parts of the country, the
Yeah.
three panels, the lawyers will be in different places, and
Yeah.
I mean, it works beautifully.
Yeah.
And to just
Well, yeah.
throw that out the window is going to reduce efficiency and quality.
Yeah, and I think they're definitely going to keep it telework for examiners, but the PTAB, I guess, I think some people didn't like the judges were remote, so I think they are changing that.
Why don't they like that?
Because I guess if you're let's say you're a patent owner and your patent is about to be invalidated, I felt some of them felt that it wasn't right.
Well, then it doesn't make any difference whether they're sitting in Washington or they're sitting in Denver.
I guess
I have to say that after the PTAB got
yeah,
put into, obviously that was after my tenure, but I would go to a lot of these conferences and meetings with them. And I mean, the credentials of some of these people were just amazing. I mean,
yeah,
and I think, you know, compared, but one of the reasons I think that you could really attract high level people was because they could telework.
yeah, and absolutely, and I think that's why the USPTO kind of knew that they couldn't get rid of the examiners for that. You know, as we're wrapping it up, I guess you know, one of the things we were discussing before we were recording about like all the people that you got to know in the IP world. I think you've known every USPTO director except you said you've met except Kathy Vidal. One of them you mentioned Judge Pauline Newman. Can you just tell us a bit about how did you first meet her? And
Pauline Newman?
Yeah, yeah,
Yeah, she was. Goes back to when I was on the Hill. It actually goes back to the patent term, the Hatch-Waxman Act,
yeah,
and she was I think it was I don't know if it was the IPLA yet or the American Patent Law Association had a little committee, and there was a group of three or four corporate patent counsel from, and one was from, and they were all really high level people. One was who later became head of the PTO himself, Chief Patent Counsel of General Electric. Oh, it's terrible. Harry. His name is Harry. Anyway, he and she was in this group of. I mean, these were a handful of the most senior corporate patent counsel for big companies in America, and she was in that group, and so they would come and visit me regularly, and I became with her. It was more than just I became a personal friend of hers, and I remember once she used to have an apartment in she was living in Philadelphia then, but she had an apartment in New York in Greenwich Village.
yeah,
And a little studio apartment. I remember one time I went up there and I met her. I went to her apartment in Greenwich Village, and we went out for dinner in the village. And she's a tremendously interesting person. She was when she was a young woman. She worked at UNESCO back in the early days
Yeah.
of UNESCO in Paris. She lived in Paris. Anyway, and she's just a sweetheart. She's just such a nice person and really smart. And in terms of but she is a absolute rock. I mean, she is as pro patent as any human being can possibly be. She is, and that's why she's been a thorn to a lot of her colleagues,
Yeah.
because she comes almost without exception down on the side of the patent holder.
Another one I thought was interesting you crossed paths was John Squires, back when he was chief, I guess, chief IP counsel, chief patent counsel at Goldman Sachs.
Yes.
Do you remember?
Yeah, well,
yeah.
I didn't have anywhere close to the
Yeah.
relationship with him. That with him, it was just, I believe I went and talked to him when I was trying to get support for my not-for-profit, and he couldn't have been nicer. But business. I mean, he was a pioneer in business method patents.
Yeah.
Because he developed a patent program for Goldman Sachs. I mean, people in the financial industry previously never thought in those terms, and so he was really a leader in that. And I can't remember if it was on those issues or it was because anyway, I visited him in New York a couple of times at his office, and he was a really nice guy.
Before we wrap this up, you mentioned that actually after we finish recording this, you're going to go to a board meeting of an organization you're part of, La Musica. I was just curious about, you're retired now, but what, out of all the things you could be doing, what made you choose to get involved in an organization that promotes music?
My life has always been associated with the law of creativity, of course, both on the artistic and literary side and the technology side. From just a boy, I have really been into classical music. During all my years, I mean, I think one of the most horrible things right now in Washington is closing the Kennedy Center. I was a regular at the Kennedy Center from the week it opened until the day I left Washington, and so I, went to concerts and operas and plays and stuff constantly. And so now that I don't have to work anymore and don't have any desire to work, I don't want to have any pressure at all. Unlike some people I know who just have to, keep going, keep going. I feel here I live the life of a 18th century aristocrat, like somebody who's living at Versailles. And so their day consists of getting ready for the concert or the theater that they're going to. And so I've become involved in, Sarasota has a huge performing arts. So I'm involved with the Asolo Repertory Theater, and we have an acting conservatory here I'm involved with, and then I am past board president of this chamber music organization called La Musica, and under my leadership, really, it's been going for 40 years, but the old maestro was an Italian guy, was like 90 years old, and he basically couldn't come anymore after COVID. So we had a big crisis of leadership, and we ended up recruiting this woman, Wuhan, who is the director of the Chamber Music Society of Lincoln Center, so it doesn't get any better than that.
Yeah.
I mean, that's the epitome of the world. And so now La Musica has become basically, Lincoln Center in Sarasota.
Any particular music you like to listen to? You said classical music, but any piece or anything, composer, you mentioned Mozart, that you like to
No, actually,
listen to?
Mozart is not my favorite at all. I tend to like, well, your taste changed a little bit, but I guess I like, for a long time, I really like what I would call late romantic music, like Rachmaninoff, mean, starting maybe with Brahms, Rachmaninoff. I've developed more of an ear, I think, now for 20th century, and now music.
Oh, that's pretty cool. Thank you, Bruce. Thank you for joining Clause 8 and telling part of your story.